Good evening to everyone, and if you cannot see the slides on screen, let me know. I think everything should be set up. So I appreciate everyone who's online and in the room, thank you. And tonight we're going to do a taster lecture, which is an example of the kind of teaching that we do here in the LL.M program in Public International Law. So let me say at first that what we do here is give you an overview of what it's like to be a student. Applications are still open. There are several weeks ahead of us still to apply. So if you are interested after this, please let us know. There is another information session coming up as well. And we're always open to questions that you can email or contact us through the website. So with that, let me say tonight I'm very excited to go over this topic. This is lecture 3 in a series of 4 that we've been putting on in terms of what I call the remote border. And by that, it's the border that is no longer physical when someone reaches a nation. We used to think of physical presence as being the requirement. But now, what we're going to look at is academic freedom and how it intersects with this remote border. So let me say, my name's Andrew Mansfield. You probably all know that at this point. I'm an assistant academic coordinator here for the program, and very excited to be giving you this overview, as well as to be available, like I said, for all questions on the program. So tonight, what are we going to do? We're looking at a very particular test. I think this is, I like to consider this almost the way we run a test through a system. We could take the test higher, we could even push the test lower, but at this point we're taking the European Union. The goal tonight is to examine this remote border, but also to examine academic freedom. They're almost both co-equally important in the way we're going to do this. We'll explore the information tonight. But we're going to run through the system of the European Union's fundamental rights system, what it means when a non-EU or a non-Schengen area scholar or someone who doesn't have easy short-term visa-free access tries to come into an academic environment here in Europe and discovers that their way is blocked, that somehow what's happened is before they reach the border, the physical border, the invitation to participate is not effective. So what we're going to do is test this entire remote border system, and love to answer questions at the end. We're going to test the whole system against this particular freedom in this particular European context. But again, I want to stress that we could run all kinds of different tests. Let me make sure my slides are advancing. We could go above and beyond this. We could go to fundamental human rights. We could go to international human rights systems. The question is, what level do we want to test? So tonight, I would like to open with a hypothetical, complete hypothetical. There's a giant disclaimer here. This is not a reported case, not a real case. Don't take anything from the sound of the name, but Dr. Amina Farouk, my example is at 6:40 in the morning, is ready to depart. A doctoral defense here in Vienna. It's 3 days away, and of course the host institution here in Vienna has set up all of the proper documents. There's also a conference panel that she's going to participate in here in Europe, and she's got everything. Her fees are paid, her hosting letters in her bag, but this is what happens. This is the remote border, right? She gets to the airport and goes through the check-in line, presents her passport, and is told at that moment on a screen that she can't see that she's denied boarding. There's no explanation there. There's no appeal at that moment. There is nothing that she can do at that time to get on the plane. In fact, we can see later the remedies are not temporal. They don't go with this problem in the sense that we'd like. So, does that violate a European Union charter right? That's the question. Is there a fundamental right at this point that this is interfering with, and what does that tell us about the system of this remote border? So again, I put up on the board where, this is what, as public international lawyers, we need to consider, where does the legally relevant act occur, right? Was it here with the check-in desk? Is it a consulate somewhere upstream? Can we blame a database, an automated record, an algorithm, or is there a legislative choice somewhere that we can identify that led to this denial of boarding? All right, so hold this in mind as we move forward. The system that I want to go over here, we'll go through 5 different steps, right? The first is, where is the decision about presence really taken? And does it, in an institutional sense, trigger charter rights? So academic freedom, under Article 13 of the Charter, has an institutional dimension here in Europe. And I want to be very clear, we're not trying to establish that all academics, for all purposes, should have open border rights. I might feel that, I might think that, but that's not the legal argument in any way for this presentation tonight. So what we want to do is we want to look at that Article 13 right, what it means in Europe, how it's been litigated, and then where in this chain of events can we identify the decisive moment, right, where we can say this is when something happened that interfered with that right. Now there's another element to this, and this, it's a paper I'm working on, I'm presenting in several weeks in Graz. If we have feedback, if anyone could make sure that their microphones are off at the moment, that's wonderful. But I'm presenting this paper at Icons here in Graz, and the question is, this is a big move, but I want us to work on it together tonight, right? It's attribution. Can we need to find a European Union institution, an involvement, some form of an actual European Union regulation, law, anything that we can identify that it's this hook that's going to give us the right. And attribution is that what happens at the airport, it looks like a private carrier refusal, right? We can't use this schema as much as I might like to challenge a truly private airport decision. If it's an airline decision, that's going to be something else. What we're looking for is if there's a hidden public law record under this that we can put together here. And then finally we'll look at remedies, right? I call this time, temporality, distribution. One thing about academic freedom that's different is that if a person misses some of these events, it can't be fixed, right? It's not reparable through a later apology or some kind of damage. In the United States, we do attempt with money damages to make up for things like this. There's injunctive relief, which is actually a court interfering to say, no, this must move forward. Given the timetable here, what we're trying to identify is in the European context, in the international law context, what can we say about this? If we can't fix it, does it impact the academic freedom? And again, I have chosen this partly because the conference is on academic freedom that I'm speaking at. But we could choose any charter right and run it through this system. We're testing the remote border, and we're touching it against different rights. So I just wanted to say there's the right to family life, privacy, religious assembly, the right to journalistic freedom, artistic performance. All of these would also make excellent test cases. If these fundamental rights break down, this is my point tonight, let's try and come back to this. If these fundamental rights break down and don't work through this remote border system that we've created, then the question is, should we be critiquing this border? I think so. That's the focus of my work, and I think we'll see that it does not work for these rights. Okay, so where does the journey begin? In the earlier lectures on this topic, we've talked about this today. It begins far from when one shows up at a border station, right? That's the main point. We often think of, and I call this the presence assumption, we often think of, in terms of the academic freedom, that we want to protect a scholar who's already here, a scholar who's arrived, who lives, who works in the union. That's our normal framework for academic freedom. We think, greetings, that this is what we protect, right? But with the remote border, we're asking a different question. If a person cannot even get to the union, if a person cannot enter to actually enjoy that freedom, and we can trace, like we said, a European Union action, regulation, law, some kind of actual decision, the question is, the remote border might have moved. Can we move the rights assessment as well? That's what we're trying to ask here. And I do want to bring up that we have the European Convention on Human Rights, a different level, a different environment, different number of countries. We have Article 10, which concerns the right to scholarship and freedom too, but it's a different fit, and we're not using it here. We're staying at the level of the European Union in Article 13. All right, so what does that mean? We need to start by moving through the system that I've talked about in a lot of different lectures. And that is that we now have these layers upon layers of regulatory or permission systems, and they're getting more complicated, right? The question is, when we dilute what's happening, when we can't tell what's happening through these various systems, are we losing the law that's behind them, right? And just to go through them from left to right when I'm facing this way, the issue is that we normally start with a visa, right? A visa is a very traditional instrument. And under the visa code in Europe, a denial of a visa is indeed a European action that can be appealed. But we want to move beyond that because we're trying to go to what's less transparent. The question is that when our researchers showed up at the airport, there are these now united systems that are running together, right? So what do they stand for? The first is the Schengen Information System, SIS. It includes information on overstays, refusal of entry, alerts for people entering the Union. We have the Visa Information System, VIS, another database. It contains short stay visa application information and decisions on those visas. The next layer, EES, right? The Entry-Exit System. This is the new one. This is the one that has had a lot of information in the news with backups at the airports. It is a new unified system to grab not just passport data, but for non-EU citizens, non-EU residents, to create a biometric record above and beyond and behind the passport. So for folks like me, I have 2 passports and 2 citizenships. When I enter, I will be, well, now I'm a resident, but if I was not a resident, when I entered, I would be judged on my biometrics and my passports would come up instead of presenting my passport and then presenting myself. All right, so we have a very deep biometric system that we're building out. ETIAS, the next system up, let me get my acronyms right, the European Travel Information Authorization System is going to be, much like the United States has done, an entry system for those people coming into the Union that would otherwise be, have a short-term stay exemption. So we've got all this data collection happening, a lot of it inside. We could go to other things. I put a note down at the bottom, it's in small print, but API and PNR are more acronyms, acronym soup. That is yet another layer at the international system for air travel, for border control at this point. It's advanced passenger information, passenger name records. So under a global treaty, first of all under the Aviation Convention and EKO, we call it, there are mandatory, and then the United Nations backed this up with the Security Council resolution, requirements for airlines and those providing transit and travel to collect data and to transmit it upstream and downstream. It includes everything, interestingly, from credit card records to meal choice to seat selection, prior travel history. That can be shared. It's being shared the moment one buys a ticket. It's then being shared when you come to the gate or come to the check-in counter, and it can be shared when you finally reach the border. So this information is moving up and down and around. We're focused on the European layer, but they do work together. So think about the fact that all of these data systems, including now algorithmic risk assessments that are analyzing the entire pot, the entire set of data, and that's this interoperability regulation. So we've got 2 regulations here in the EU. They don't unify the database. That would be interesting. But they make the database share information between all these data layers. So now they're handing off what might have been immigration, what might be border control, what might be simple travel, pre-authorization for otherwise visa-exempt individuals. All of this is being combined and made available to the member states, to borders, to border guards, to airlines. This carrier interface sits on top. So, we talked about our academic, right? We started out with, you may not board. Okay, why? That's the only visible act when one reaches the airport and can't get on. In fact, there's a system that actually says on screen, if you could see it, okay, not okay, and it has two codes. When we're checking in, presenting passports, trying to get through, in the first instance, that's what the airline agent is looking at. Even if one is pulled aside for secondary screening, you can have the gate agent try and intervene on that information as well. A no, for any reason, should be the stop. Now, why? Because there is tremendous the financial penalties, incentives on the carriers under international and European law that if someone boards and doesn't have the proper paperwork or authorization and shows up, not only does the airline need to take them back at their own expense, but there's huge financial penalties. So think about that. The incentive is entirely on a commercial operator to avoid penalties. There's no penalty or incentive to make sure academics, or anyone, but certainly not academics, the subject of this presentation, get through. Who in the system is trying to ensure freedom of travel and freedom of academic exchange? It doesn't fit in to what we've done here. All right, so the question is academic freedom an institutional right or a personal right in the European Union? And how do we expand that to people coming here to participate? The main case that I've based this presentation and this paper on is very famous, now with Hungary having changed governments, we'll see. But right here, not far from us, we have a very tremendous institution. And the case is that Central European University ran afoul of the former Hungarian government, and they passed what appeared to be, we'd call them in the US at least, facially neutral sounding regulations that in effect almost only targeted CEU. And as a result, Central European University had to mostly leave Budapest and relocate here to Vienna, where most of the school is to this day. So this is now approaching a decade old. But what happened in the European Union was that this was challenged as a fundamental attack on academic freedom. It's a different way we think about it, right? We normally think of the scholar getting censored, controlled, somehow told what to research, punished, perhaps losing their position. This went beyond in the European Charter context, and this case is also called Lex CEU. It went beyond the individual. The question was, if the state, under the EU, inside the EU, can eliminate an entire institution or can control an institution, that automatically hurts and somehow infringes the freedom of everyone who would work there, who would travel there, who would study there. So there can be an institutional dimension, right? That the individual should be free to choose their topic. They should be free to publish and teach and research. That's kind of the traditional wisdom, what we always think of. But the institutional dimension is that the organizational fundaments that make research possible also have to be free. The institution has to be free to design itself, to invite who it wants to participate. to present classes or seminars or presentations that it feels are academically important. So there is an institutional dynamic that goes far beyond the individual academic freedom we'd normally think about. So what is the Article 13 effect here in the Union? That where any kind of governmental action, European action, impacts the very structural or infrastructure of academic life, we need to look at whether Article 13 is being honored. All right, that is going to be my hook. Whether you agree with it by the end is an open question. There's a couple big moves here, and I want to be transparent about them. That is one, and I'll show you why. The other we'll get back to was the attribution question. But for now, let's move on from Lexi EU and say what are we looking for even in the border? So again, I want to be very careful. Article 13 does not create some kind of an open border right for academics. What we're looking for is in this test case only. And I admit this is we're taking a slice, we're taking a thin piece of academic freedom here, but we're testing both academic freedom and we're testing this border system. So we need to look for a protected institutional decision, right? This isn't a normal short stay visa for an academic. So what we're looking for first is the institution itself to arrange for someone to come in, invited to or being on the defense panel in our hypothetical, presenting at a conference, being invited to work in a research library. Those are the kind of things where the institution inside the EU itself is pulling in a different academic researcher. And please make sure your microphones are off again too. We have a little bit of feedback. All right, thank you. So the concept is visa authorization, recordation of stay, carrier verification duty. Those are the things that then regulate this presence, right? The institution has asked someone to be involved, has set up its own institutional structure, and now we have to have that person pass through this remote border system. All right. The hypothetical, the scholar doesn't get through. We're looking for, was the reason, we call it causation, was the reason the scholar didn't make it through this net, the very regulatory system of all these databases, and is it attributable, again, to a union activity, union legislation, right? Article 51 of the Charter makes all of this on, or brings it into play, only where the member states act within the scope of European Union law. So again, we're looking for a touchstone. Here we've got a lot. We have the visa regulations that we talked about. We have ETIAS, we have EES, SIS, all of those very same things, which in some sense I was criticizing as creating this remote border that's so hard to get through, are also touchstones of regulation. So they're providing for us a basis to challenge this very academic freedom impairment. All right, final element here. Is it material? Did the absence make some major difference, right? There has to be a temporal aspect. We're looking for damage in a sense that can't be undone. The conference was missed because it went forward. No one knew at the airport that our researcher wasn't getting on the plane. Unless they're the keynote speaker, perhaps they'll come up with another keynote. It might just happen. Did the defense panel happen? Did they miss their time in the research library? These are things that there's no remedy available for. So we're looking for these four things. And again, the test case might be fairly narrow, but we're viewing this as a test case. We're taking a charter freedom that is of crucial importance, running it through this system, making sure the institution itself in the EU has called for the researcher, who's then blocked by an actual union regulation or activity that causes harm. Okay, so normally, what do we look at in terms of coming up with what happens. We've talked about this, right? But Article 52.1 is going to make us dive even deeper into now analyzing. We've established our harm. We've established the unions involved. Now we need to look at, is this regulation legitimate? Does it serve a purpose? And in European law, we're looking first at legality, right? Is it actually in an instrument? Well, by my definition, we've already crossed that boundary because we're saying that SIS, ETIAS, all of these systems, including the carrier penalties, created the harm. In that sense, it is legal because we have a legal basis for analysis. Does Article 13 academic freedom, was it impacted at its core? Did something very substantial occur? Yes. Now, we look at border management, and this is where it gets difficult because it's one of the most sovereign, sensitive remaining topics in migration law. Is the border management function that I would say, you're going to hear my point of view, hidden, buried, distributed in these digital systems, is it nonetheless serving a public security or otherwise legitimate border option? Often, yes, it's part of a bigger system. So then we move on. Is it suitable for what it's regulating? Is it needed, right? And then is it proportional? So those are all internal to the Union EU law ways to look at and run through this interference. All right, so again, if we go back to Dr. Farouk, we're looking at what happened at 6:40 in the morning with the not okay simple message on the screen. The airline, and I've seen this happen many times in people I represent in different immigration contexts, the airline simply says, we have nothing to do with this. You may not board, period. Hands back the passport. There are ways to appeal. The European Union has a formal mechanism that would take weeks, if not months, that eventually finds out what nation, what authority was responsible for the block. Is there a way to challenge the information? But again, it's not instantaneous. What our research is doing is turning around, taking bags home, WhatsApping, messaging, calling the conference, calling the institution. It's not happening. And I'm not sure why, but I'm not going to be there. All right, so again, apply the framework. What I'd be interested in is if the conference is Thursday, if the panel's Thursday, again, we need to decide, right? Let's think about this together. What is our academic challenging? What is the law? What's the thing? What's the legal basis? A record? An act? A response? She's standing there. The carrier has no idea, in essence, what's happening. All we know is freedom's blocked. So, point A, it's very difficult, right? That's the point. Now, we then run through what we just talked about. Is it inside EU law? Is it part of Article 51? And we go through the proportionality, necessity analysis, materiality, and making sure that Article 13 is engaged. Now we're down to, what in the world would an effective remedy be under this border system? Is there an effective remedy? And this is the real crux of this entire presentation tonight. If academic freedom, one of our most cherished institutional and individual freedoms in the European Union, can be blocked by this remote digital distributed border system, an algorithmic system, if that freedom can be blocked under the hypothetical that I've given us, under this path, then many other freedoms are not going to pass as well. Now again, we move up, we move down, we move to an international human rights environment, we can move to national structures, but no matter where or how we deploy this, my point tonight is, and I intend to develop this, the paper is almost complete for the ICONS conference. This is our test case. This proves to me that something down here is not working, and it's going to get more complicated. It's going to get more distributed. less visible and less subject to remedy with every passing year with further interoperability and digital databases. Okay, again, I said we would talk about attribution. This is our chart that I hinted at. What does the scholar know? Well, if the screen's turned around at all, which I doubt it would be, there's our codes. There's our entire travel. Go, no go. Okay, not okay. Two different options. ETIAS, for those who would otherwise have short-term visas, denied. EES, some kind of broader visa entry problem, denied. That's not very much information. So what the scholar sees, an agent of an airline, often hassled, maybe with 15 other people trying to bring bags to the counter, not with a tremendous, shall we say, international legal education, but working from a manual, working from a phone or some kind of system to appeal the internal to the airline system. What do I do with this passenger? They're not going to risk the fine. The airline, and especially the employee, is not in any way incentivized to make sure that the system works for the freedoms that are being impacted. The only thing is penalty avoidance and enforcement of this remote system. So, this is a loaded word, but my question is, what is the law hiding? What is the law obscuring? Maybe we can try and make it more neutral. When we have this many layers of digital interference with the rights, these fundamental rights that we could test one at a time, and today again we're testing academic freedom, the question is, upstream, if we keep tracing this, where is the union legislative or regulatory act? How do we get to it? How do we challenge it? First we have to identify it, right? So I'm using here let me go back to this one. There's other cases, I need to expand them. They're on things like banking regulation, credit denials. There's European Union law that one has the right to inspect data that impacts you, that there should be some kind of appeal, that there should be visibility. And we can use that attribution to say that where upstream a private actor is taking an action that's basically enforcing a legislative or regulatory function, it's been offloaded, it's been delegated, that we can attribute that all the way up the chain to European action, to government action of some sort. We don't have to say it's a carrier decision. We can do nothing. Now, to be fair, if it was truly a carrier decision, there might be a private right to deny travel. But we would have to know that it has absolutely nothing to do with government regulation. Private action by itself does not fall in this regulatory scheme. All right, so again, there's three different routes here, but I want to call them recurring scenarios, right? What could be happening? The first is that the SIS alert or the visa refusal could be a lawful adverse decision. It should be open to review, and then if there's an appeal mechanism or a review mechanism that's made available, the protected interest can be judged in terms of, was the regulation proportional? Was it necessary? Was it relevant? That's probably the easy path. But what about number two? If the information in the system, and how many of us, this is an empirical question, would feel comfortable with a system we cannot inspect except under very limited circumstance, with security limits, with privacy data not applying, and the right to access the same way because of this border situation. If there is a mistake inside the system, if the data itself was wrong for the denial, how do we push that across the same set of analysis, the same analysis, right? It's going to be a different weight here. That's more of a right of correction, a right of addressing something that should not have happened. And then finally, my bottom row here is, what do we do if, independent of all of this, the airline made the mistake? the registration system made a mistake. There's some kind of other data problem. Well, that is not attributable, right? Again, that does not flow up to my analysis here. There might be a great harm to academic freedom, but we would say that's a private action in this case. Now, could one argue that this entire web of regulation that's created by the governmental systems is somewhat responsible? Yes. Can we say that legally? I haven't found a way. We're trying to keep this testable, discrete, and really easy to see. Okay. So, Article 47, now we have, I'm using other case law here that's different than the distributed border, but there is decision law here in Europe that where, like I said, when a visa itself is denied, there has to be remedies, there has to be information. These cases also involve sharing because of the upstream nature. When one applies for a visa in the Czech Republic, neighboring states have the right to object. That again is not visible to the person necessarily getting the denial right away. Who objected? Why did they object? So we have case law, cases, I used an American term there. Let's say case is that there must be visibility, there has to be information, and that there has to be reviewable grounds as we step through this. So I think we need to apply those same, we need to take this remote order and make remote some of the law that we've already applied to similar situations. Again, we need a record. We need to know who. We need to know how. Those are going to be key pieces of information. And again, data access, which we have some rights to, but limited because of the border context, provides some limited information, but they're not a complete remedy, right? All right. This is the temporal aspect again. Why does this matter? Again, because it can't be fixed in all circumstances. It's the interference with a fundamental right that can't be repaired necessarily. That's what we're looking for as the hardest test case. So, no reason given, very difficult to understand given forms on who to appeal to, what needs to be filled out for our researcher, where the documents are sent, what are they being sent now from Asia into the European Union and routed to the correct national agency. All of that means that the doctoral defense went ahead without an examiner. Or the research didn't occur, the presentation didn't happen, the conference went forward, the opportunity's lost. The institution under Lex CEU was not able to exercise its academic freedom to set up its environment how it wanted. The individual, as a result, is impacted. But the legal remedy lies with the institution. But again, the question is, what do we do? How do we solve this, right? Under the current system, if it takes 5 months to get an answer by mail or through an online system to a foreign country about a denial that happened at an airport gate on the way to a conference, is that effective? Is there a way to expedite it? Is there anything else we can do? If not, again, this is what I keep drawing us back to. Is there something wrong with the distributed digital order that we're not fixing? All right, so the burden falls unevenly. We already went over this. The passport hierarchy doesn't establish interference by itself. One of my favorite researchers here nearby at CEU, but in Budapest, Dmitry Kochanov, talks about the apartheid passport system, the birth lottery, the fact that these color cards given out by the happenstance of where one was born control not only access to wealth, post-constructivist, post-colonial access to education, healthcare. All of these rights to live are distributed randomly by birth or by parental access, so-called rights of blood. I very much believe in that argument, but that's not what we're doing here today. We're still taking, unfortunately, the system we're given. We have to work within it at this moment in international law to try and test, ameliorate, think about remedies, think about how the system works. So my paper here and some of the other work has not challenged, I'm happy to do so, has not challenged the underlying passport system. the underlying concept of nationality. I believe they're both artificial constructs. They're both things that really only go back to 1918, the very first common passport post-World War I. Before that, as I've said in other lectures, we had the right, pre-World War I, to travel almost at will. Sometimes there could be special passports for commerce, for navigation, for arrival at a port. There was discrimination in Uruguay where I worked based on the class, the steerage that one got off the boat. There were different lines. First class could simply pass in the country unobstructed. Second and third had different rules in terms of health inspections. But again, this concept of documentary, biographical birth and blood control of access to the world, it's a fairly new form of organization. And it relates to whether or not we ascribe to nationality as an organizing principle for the world today. I can't challenge all of that here. My point is that scholars, and I'll have a slide at the end like Moreno Lax, would at least point out that this academic freedom impact that I just identified today actually hurts those most subject to this system the most. Right? Many Europeans have the right to travel across the globe fairly freely with at least 90-day access. Some of the very hierarchy here means those are the most affected who have the least effective passport under this world system. The distribution of impact is not equitable. It's based on, to much of the extent, on overstay. The fear of immigration, the fear that someone's going to enter the country and not leave. Who do certain countries fear? Those perhaps most academically at need, most economically at need. It's going to have quite an effect here if we think of equity and justice. All right, so we are trying to end with enough time for questions. To run through the simple system again, we've taken one test case, we've taken one layer, we've taken the European Union, we've looked for a fundamental right, we've looked at Article 13. It's an easier right to play with in this test because the right exists inside the union with the institution, and we don't have to try and externalize it simply to the non-EU citizen. They're impacted, but the right is an institutional right to control the invitation, presentation, structure of the university itself. Has that happened behind a system that's attributable to a European Union act or regulation? Is there an evidentiary route that we can prove this? How do we go about doing it? What is the system to find out? And then will there be a remedy that can run in time? My current point is, I would answer at the moment that this is almost impossible. This is infeasible. It's not going to happen in a way that would preserve a temporal aspect of academic freedom. That to me is a fundamental failure of the remote border system, of the algorithmic border, of the digital border. If we can't take what we consider one of our core freedoms and operationalize it through, test it through this system, I think we have a lot of questions about the system itself that we need to address. And again, I put down here the same sequence, the same test run. We could create a paper, we can create presentations where we push different rights through the same system and see if they exist, if they're impacted, if they're attributable, and if the regulation's proportionate, necessary. I think the tests would all come back at this point very problematic. So, if the European Union, as a conclusion, if the international system, if we are all serious about these freedoms, we need to understand what this remote border system is doing. And I would use that as a moment to question the entire digital algorithmic remote border. We've externalized the frontier. I'm working on other aspects of that externalization for getting nations out of immigration. We call it pushback, remote visa applications, third-party detention centers. Add on top of that APR, PNR, alphabet soup of digital systems. the border no longer is the border guard. The border really isn't even the airport. The border is a system that we, as citizens, I would argue, may not have adequate control over at this point. That's the question for tonight. All right, so if anybody wants the presentation, we can make it available in PDF. There's some key scholarship here, key instruments that we went over all too quickly. But I hope that I gave you a sense of what it's like to study here, that we can work together here, that I would invite those who haven't applied, if you're interested in public international law, you want to sample Vienna, the international organizations here, and also really sense what it's like to be adjacent to and within the United Nations. There are still several weeks in which you can apply to be considered. But with that, let me turn the microphone open to you, and forgive me, I'm stepping off camera because my ability to see raised hands is over here on my other computer, but I will, at this point, pull up if there are any questions, or feel free to simply jump in and open your own microphone at this point. Or if there's any in the chat.
Andrew, hi, it's Nolan Taylor.
Hey, how are you?
Great. Thank you for the lecture. This is a morass of complex issues and somewhat troubling, but two that strike me that I'd like your thoughts on. One is the first problem is the denial at the ticket counter by the carrier.
Yes.
There's no due process. There's no information about why, and there's nothing that can be done in the moment, and there's no remedy. So that problem is unsolvable within the current system.
Yes.
When it needs to be solved. The second problem is this scholar unwittingly finds herself or himself on a no entry list or a a no travel list.
Yes.
Without knowing why or who made that determination. And it could be a determination by the host government that this person has published information or papers critical of the government. I mean, who knows? It could
absolutely.
Or it could be a mistake, right? But that takes 5 months to sort out, provided you can figure out how to appeal and who to appeal to. So, and then the GDPR issues of this person now has a record on them that is adverse for some reason, and it seems like potentially a privacy law violation as well. But so interesting web of issues to sort through.
No, it is. You've identified it exactly right. When I try and categorize it, again, the 3 layers, and we could divide it into more refined layers, but you've put your finger right on them. How do we separate, I mean, putting aside what you've identified, the due process really bothers me in this system, and I don't have an answer yet, right? When someone has, in effect, played by the rules, has a valid passport, has obtained a visa, has made arrangements, done whatever they need to financially to be someplace, and the denial occurs on a system that truly has only 3 points of answer with no data, that's a problem, right? We've identified a due process problem, you've called it. How do we solve that? But the other layer is from error to intentional blocking for our scholar. And again, we could apply the same thing to family life or to religious freedom. We test these other fundamental rights. We need to figure out where the right's located, who holds it, how to test it. But all of that needs some kind of traceable record where we can identify the actor, where we can identify the regulation, find some reason. Now currently, we could do another hour together, unfortunately, on remedies in the European Union. They're all distributed, and we now have these databases that are coming together. But we have remedies that are not only snail mail slow, but also with national authorities. And we have to figure out who, where, how to appeal, what to ask for, what forms to use. And the question is that even that path real? If we're telling someone in Nairobi that they have to figure out who properly in the national authority in the French government receives this data request and how to process it. Are we requiring them to hire a lawyer in nation, in effect, remotely, to pull up this information? I mean, again, it's all troubling. You've said it exactly right. To me, this is why, as I try and unwind these layers, right, and on top of this is the EKO and the United Nations itself with passenger information. We could add that, and then we'd have even more distribution of different national systems. The question is, what do we do about that, right? You're exactly right. My work today was simply to touch, and I think that's really the point, to touch a freedom to the system, to test a remedy, test proportionality, and ask, does this work today? And my fear is the answer is no. And people are attacking this externalized border from all kinds of perspectives. But this is one that I wanted to make simple, in a sense, even though it is so narrow and so pointed, right? An institution invites the academic who hits a barrier attributable to the EU itself that's eventually traceable to the EU. How do they challenge it? But thank you for your question. That was a long answer by me. If there's other questions, please. Or if there are any... Yes, please, go ahead.
No, I think Farhana is raising a hand. Can you please speak? And I will read the questions on the chat afterward.
Thank you.
Oh, hey, thank you so much. I'm a former police officer from United Kingdom, London. And obviously I was thinking to joining the course.
Yes.
Is there any chance this course is online or you have to attend in person? And how long is the course, please? Thank you.
In terms of getting the materials, could you repeat the question?
In terms of getting admissions for this course.
Oh, yeah, for the program itself.
Correct. Thank
yes. It's all available both through a UN page and through the Sigmund Freud University website. We can make it available we've got your email. If you'd like more information, we can definitely send you the application link. But perhaps we can make it available in the chat too. Deidre, Director of Admissions, is with us. But we would love to consider your application if you're interested in the overall course. There's also another information session coming up on the overall LL.M. This one's to give a real specific sample of teaching research. But inside the Public International Law course, there's the ability to undertake this or any aspect of public international law, even touching international relations, all the way to human rights, whatever is of most interest to you on top of the courses to do your thesis in. So I hope that answers the question. I'd love to see your application if you're interested.
Thank you so much. Yeah, I got the link actually on the chat box. I'm going to actually email tomorrow with my CV and everything to see if I'm qualified. But thank you so much. I appreciate it. Thanks for the class. It's amazing. Cheers.
Absolutely. Thanks for joining us.
So we have 2 questions from the chat. The first one is something about future lectures. Will you organize any open lecture series on other topics of public international law, including privileges and immunities or law of international organizations? Or is that something that another lecturer would have to do as a specialization?
The only other lecture, let me back up and answer that one first. We do have a 4th in this series lecture coming up in several weeks, and you'll see publicity for it, but it's right in this theme. The next lecture that I'm giving as a sample of what happens here is called The Grammar of the Passport. And it's about, I'm looking at the information technically required for international travel and how it's regulated at the international level under the Chicago Convention, under what's called EKO 9303, the Technical Specifications Manual. There's an interesting tension that the content of what nations put in passports, while being perhaps the most trusted theoretical piece of information on identity out there, is not tested by anyone. There's no, other than a nation swearing what it gave is true, there's no authority upstream to test what's on a passport, though we have this gigantic environment of what goes on a passport and how it goes on. So that's what we'll explore in the next lecture here, the taster lecture. What you've identified, the immunities of international organizations, is explored in depth, but in one of the main courses. There's a course here in international organizations during the LL.M. itself. That course, interesting to me, I came up through human rights from my primary focus. Theology, then leading to an LL.M. in human rights, coming out of an international law degree. International organizations law is a very interesting field, and it does deserve a lecture. We don't have one planned. There's an entire course in exactly what you're specifying, which I call the personality of legal organizations, right? What does it mean to be an organization? Where does it fit? It's an interesting concept, right? We have normal international law, state to state, classical relations. We then invented post-World War II more and more, came out of some very specific pre-war, perhaps, organizations. But then post-World War II, we start bringing human rights from states down to people, people to other states, state to enforce human rights. And then we get organizations. I mean, we can go back to the International Telegraph Union, one of the very first ever founded. Very specific technical 1880s, 1890s, the mail postal regulations. These lead up to the League of Nations, the International Labor Organization. Suddenly, all of those spill over, they decline. We have World War II. We emerge with the United Nations, and there's a very early case law you'll explore on, is the United Nations a person in international law? All right, long-winded answer. I would love for you to be in the course, but I don't have a lecture planned on that per se.
There's also a question from Shanta. I think in terms of scholars' discussions, has there been any time that scholars used to discuss the world should be free from visa entry or whatsoever to make the world, I suppose, be able to travel freely? Has there ever been such an attempt?
Absolutely. This literature that I would call jus nexi. And Dmitry Kochanov is one of the main proponents, but did I put yes. Babula, Moreno Lax, these scholars are very much what I would call, it's more philosophy, well, that's not quite right. It's a normative, we would call it a normative prescription, just like this question is saying, just like I honestly believe in, I don't know how to operationalize it. I agree, the complete handout of every aspect of economic, social, political even, and academic, what we're talking today, rights, by random distribution, seems to present all kinds of equity and justice problems when we really think about it. Right? What right do I have based on birth? If I'm born in Uruguay or Argentina, but I had a great-great-grandfather who came from Italy, I can now get a European passport and take advantage of everything here. Why exactly? I mean, there's all kinds of troubling reasons that you could say the old sovereign system, right? The concept that the king, the crown, owned the land, subjects lived inside this border, subjects could travel to other realms, they could pass freely, but one belonged to a state. That transforms itself into this concept that we are registered with states, members of states, that polity has to take us back. It has obligations to us, but it also owns us in a sense, right? There's an international right to leave a nation. There's no right to enter another nation. Is that a functional right? These are all deep questions. The literature does address this. I'm not sure, again, how to make that a normative prescription in today's world. We're moving the other way, aren't we? We're moving across these digital systems, these distributed systems, from pushbacks to remote visa processing. It seems to me we're certainly not at the moment moving towards a more open, border-free world. Could one conceptualize a more just environment where if borders were open, this was the old dream of the liberal world order. that I worked in for many years. If we could have free trade and free distribution of goods, free exchange of information, international trademark and copyright, the World Intellectual Property Organization actually regulated at a high level, the concept was at that moment, the work would distribute itself to the right level at the right nation. And just like in the United States or in England, in the United Kingdom, Europe, that distribution would then bring everybody up together. And once we started producing things at the right place, at the right cost, everyone would rise. In effect, we'd all unionize together in the old 1950s America. But then that was supposed to lead to open borders. I remember talking about it in 1992, that the free trade of goods and services was just a precursor to once the world was more equalized, we wouldn't have to hold out others. We wouldn't have to fear them. We wouldn't have to block them. What are they going to take from me in my economically privileged area? That's why I need to push them back, right? I have it very good here. The post-colonial world that perhaps the nation I live in left different nations has disadvantaged them, has harmed them in world growth. Now we're blocking those very people from even traveling, learning, enjoying the United States or Europe at this point, other Asian nations, even across Africa to each other. We are just putting up barriers. I think people are afraid. We want to protect what's ours. So, should it be discussed? Yes. Will it be discussed? I hope so. I'm not quite sure where it will go. Public International at this moment is not ready for it. Not at least at the sense of, is there some justiciable right? Is there some treaty right? Perhaps. What I'm trying to work on are the edges of this. What does the passport mean? What do the borders mean? How do passports work? How do visas work? And most importantly, what happens to those most in need, refugees, when we say they need to be processed in a different country? These are all part of the same remote border. All right, any final question? I've gone to the end of our hour, 3 minutes over. Maybe one more question if it's by person or in the chat. Thanks, Deidre, for I'm not in front of the computer to see the chat if there's anything further.
There was just a frequent request to ask for a transcript of your lecture, a live, but I don't think we recorded or transcribed it, right, from your side. No. So, yeah.
Now what I can do is after the ICONS conference, if someone emails us, I can send the pre-publication paper if one wants it.
Right, yeah, I gave the email address for the copy of the PowerPoint presentation PDF format.
Oh, absolutely.
We can send that by email, and then I'll CC you in case they want a copy of your...
Absolutely. I'd be happy to share the...
Your paper.
Share the paper that's kind of the behind the scenes of all of this. All right, well, thank you to everyone. Thanks, Deidre, for helping coordinate as always. And for those in the room, always wonderful to have you with us and online. So I look forward to, there's another info session. Please look for information on it. And if one does want to join, if you would like to join the very last lecture in this series, I look forward to seeing you in several weeks on the grammar of the passport. All right.
I'm just going to post the link to the information evening in case they are interested.
Absolutely.
That is August 26th. Great.
Perfect.
Thanks, Andrew. Thanks, Deidre.
All right. Have a good night,
so
everyone. I'll log off. Thank you.
Thank you. Bye.
Thank you so much.